Select Committee.
I call Dennis O'Rourke.
Mr Speaker, New Zealand First supports this bill emphatically. We don't believe that it is a matter of political spin, as some have said. What we do see is significant and understandable public concern about serious offending while on bail, and a problem which is increasing. But the bill does need scrutiny on detail at a later stage to ensure that the rights against arbitrary imprisonment and the right to presumption of innocence remain protected properly. New Zealand First does support the bill's overall intent to strengthen bail conditions and limits, to make bail for serious and drug offences harder to get, to streamline procedures and to extend district court powers to avoid the need to go so often to the High Court, and to codify and improve rules against electronic monitoring. I think those are all very good objectives which New Zealand First wishes to see promoted in this bill. The proposal to require an accused to prove his case, the reverse onus of proof, for serious and drug offences, I think is essential and properly replaces the onus of proof and places it where it should be, on the defendant for bail considerations, as opposed, of course, to the onus of proving the charge itself. I see no inconsistency in this, because it is a reasonable presumption that if there is adequate evidence to support a charge in serious and drug offences, in other words, a prima facie case, then it is reasonable to presume that there is heightened and sufficient risk to refuse bail. Those risks, of course, as we know, include the risk of absconding to avoid trial, which I think is the primary risk, and, of course, the risk of reoffending, which, although a secondary risk, is the one which now requires particular and much more attention. And I note that from the impact statement, it says that while, quote, a reverse burden of proof is unlikely to change the court's decision on bail for defendants who pose little risk of offending, absconding or interfering with witnesses, however, in marginal cases, for which I would read serious cases, a reverse burden of proof increases the likelihood that the defendant will be remained in custody, and I think so it should. Mr Speaker, the innovation, as we know in this bill, is the imposition of the reverse onus of proof for serious and drug offences. The new Section 9A applies to defendants over 17 years charged with murder. And I note again from the regulatory impact statement where it says, of the 156 offendants charged with murder who spent at least some time on bail, 21 or 14% were convicted of at least one offence committed while on bail. Now, while one might say that's a relatively low number, it is still a serious number, and while it is generally of a low level, one could validly say that while the number is low, the potential effect or impact may be very high. So it's a serious matter which needs attention. I note also that the new Section 17A applies to defendants charged with a serious Class A drug offence. And again, in the impact statement, it refers to the period 2004 to 2009, where 34% of offendants charged with serious Class A drug offences offended on bail at twice the general rate of offending, which was only 17%. So what we see there is, of course, a much heightened risk. Both of these new provisions will go a long way to satisfy the public concerns which New Zealand First observes in these particular sorts of cases. Another worthwhile innovation, Mr Speaker, is the move away from mandatory bail for under 20 years of age defendants, where the defendant has previously been imprisoned, because again that shows a heightened risk, which is what we need to pay attention to, while at the same time preserving the balance of the need to protect young people and at the same time protect the public. So I think that's a good and proper balance in that situation. Another innovation is sections 16 and 17 being amended to cover the offence of attempted drug dealing, and it is of course logical that that should be included as well, because it's just as serious in every respect as actual drug offending and needs to be dealt with in exactly the same way. New Zealand First also welcomes the codification of the rules relating to electronic monitoring. That practice has proved its worth. Electronic monitoring does work as a form of monitoring, and the existing rules in relation to it, which have been developed as part of the common law, also work and deserve to be incorporated into the statute as well. The additional provision to ensure that enforcement of maintenance officers having access to premises is also a very important provision in the new bill. We think these are sensible and necessary, and that it is proper that there be an offence of refusing entry to an electronic monitoring officer who may be just entering to maintain the device and to make sure that it works properly or to attend whatever other problems there may be. Good, sensible stuff, we think. The bill also makes other welcome changes, and I look forward to examining those in more detail at later stages of the bill, especially looking closely at the repeal of section 73 to abolish offences bailable as of right. But no doubt all will support the re-empowering of JPs and community magistrates to reconsider bail where bail conditions have been breached. These will be very welcome to the community that sees that as a significant issue, and it will add some necessary and effective means to discipline those who breach bail conditions. Overall, Mr. Speaker, New Zealand First does support the bill, and while we believe it's somewhat related, we'll be pleased to support it to the next stage for further examination. Ultimately, however, New Zealand First certainly does want to see that this bill is enacted substantially in the form which we see today.
Call Ian McKelvey.
Thank you, Mr.